Workshop 2. Workshop.
You do that? Do we start? Hi everyone, thanks a million for joining us here today. INCLO is very happy to be here and very grateful to the organisers of IGF. INCLO stands for the International Network of Civil Liberties Organisations, and it's a network of 17 national civil liberties and human rights organisations worldwide, with member organisations across the global north and south that work together to promote fundamental rights and freedoms. I won't mention all 17 members to save time, but they include ACLU in the US, the Egyptian Initiative for Personal Rights in Egypt, Contras in Indonesia, the Association for Civil Rights in Israel, and Liberty in the UK. And we welcome 2 new members just this year, Al-Haq, based in the West Bank, and Connectas in Brazil. We also have member organisations in Ireland, Hungary and Argentina, which is why we are here today. My name is Olga Cronin. I'm a Senior Policy Officer at the Irish Council for Civil Liberties, which is a member of INCLO. Adam Remport, there, my far right there, is a lawyer at the Hungarian Civil Liberties Union, also a member of INCLO. And on my right is Tomás Ignacio Grifa, a lawyer at the, excuse my Spanish, Centro de Estudios Legales Sociales in Argentina, otherwise known as CELS, also an INCLO member. And we are also joined online by INCLO's technologist, Victor Saavedra, and Timalayan Ojo, the programme manager of INCLO's Surveillance and Digital Rights Pillar of Work, who is based at the Canadian Civil Liberties Association in Toronto. Most people in this room probably already know what FRT is, but just very, very briefly, facial recognition is a biometric technology, and it uses artificial intelligence to try and identify individuals through their facial features. Generally speaking, FRT works by comparing a face print or biometric template of a person's face taken from an image that could be sourced from CCTV or social media or body-worn cameras, and compared that template of a person unknown against a database of stored face prints or biometric templates of people whose identity is known. The image of the person unknown would generally be called a probe image. The database of stored biometric templates of known people would be generally called a reference database. And if you're wondering what kind of reference databases of stored biometric facial templates are used by police, you can think of passport databases or driver's license databases or police mugshot databases. So these systems are built on the processing of people's unique biometric facial data, so the unique measurements of your face. You can compare it to DNA or iris scans or your fingerprints biometric data. Very quickly, there's 3 points I'd like to make about FRT in terms of the live and retrospective use of FRT, but also the threshold values that are fixed for probable matches and the fact that it's a probabilistic technology. So real-time or live facial recognition involves comparing a live camera feed of faces against a predetermined watch list to find a possible match that would generate an alert for police to act upon. Retrospective basically means comparing still images of faces of unknown people against a reference database to try and identify that person. Now, the European Court of Human Rights and the Court of Justice of the European Union have, views live and real-time use of FRT as more invasive than retrospective. But it should be said that tracking a person's movements over, significant length of time can be as invasive, if not more invasive, than one instance of real-time identification. For an FRT system to work, there's a threshold value fixed to determine when the software will indicate that a match or a possible match has occurred. Should this be fixed too low or too high, respectively, it can create a high false positive rate or high false negative rate. There is no single threshold that eliminates all errors. So when you think about what a police officer will get in their hand afterwards, if they use FRT, they will essentially get a list of potential candidates. Person A with a percentage score next to them, a similarity score. Person B with another similarity score. How long this list could be, anyone's guess, because it largely depends on the reference database and a number of other factors. Just very quickly, I've just concluded this picture of a man called Robert Williams from Detroit. This is what's called an investigative lead report from the Michigan State Police in respect to Robert Williams, a father of two who was wrongfully arrested and detained after he was misidentified as a shoplifter by FRT in January 2020. We could do a whole session on Robert's case, but I just thought it was interesting to show the image, the probe image that was used in his case. You can see it there. It's a CCTV still, and the picture on the right is of Robert's driver's license picture. You'll also see, forgive the slide, it's just popped over different fonts, apologies, but basically it's important to note that Robert was arrested after an algorithm identified him as the 9th most likely match for the probe image, but there were 2 other algorithms run. One returned 243 candidates. Robert wasn't on that list. And another returned no results at all. And yet he was still arrested and detained. So really the point of this is just to show the arbitrariness of this. It's not this silver bullet solution that it's often presented to be. And there are increasing number of people who have been wrongly accused due to FRT. You'll notice that all the people in these images are people who are black. They are all from the States. Sean Thompson and Sarah, not her real name, is from the UK. And there are, increasing numbers of these misidentifications happening all the time. In 2023, the US Federal Trade Commission banned the retail pharmacy agency, retail chain rather, Rite Aid from using FRT in shops, because it was creating, between 2012 and 2020, there was thousands of people wrongfully basically accused of being shoplifters and told to leave stores, predominantly people who were black. And this was all misidentifications. So with FRT, there's an immediate danger of misidentifications. It's unreliable, it has this bias and discriminatory aspect, but also there's the larger and more long-term concerns, longer-term consequences, and that is this mass surveillance concern. FRT allows police, it gives them a seismic, a shift in this kind of surveillance power. It does turn us into walking license plates, and it tilts that power dynamic further into the hands of police. So, we know and we've heard of the use of FRT against Palestinians. We know and have heard of the use of FRT against Uyghur Muslims, and protesters in Russia. But the most recent situation regarding the use of FRT, that's been in the news at least, is the use of FRT this weekend at Pride in Hungary, which Adam will talk to in a bit. This is just a brief slide just to outline the different human rights that are affected by FRT at a minimum. The right to dignity, privacy, freedom of expression, peaceful assembly and association, equality and non-discrimination, rights of people with disabilities, the presumption of innocence, the right to effective remedy and the right to fair trial and due process. INCLO, as I said, we are members in 17 jurisdictions. And we, over the last number of years, since we brought out a report about the emerging issues with the FRT in 2021, we could see that this was becoming a significant issue. We knew about the biometric database of Palestinians. We could see our member organisation, Agora in Russia, brought a complaint to the European Court of Human Rights, brought a case to the European Court of Human Rights over Russia's use of FRT against protesters. There have been wrongful arrests in Argentina, which my friend Tomas will talk about next. There was the famous Bridges case in the UK, the Clearview AI scandal in Canada, all of these various aspects. And essentially what we decided, we stood back and we thought, in many of these jurisdictions there's no legislation to underpin this use of FRT. in different jurisdictions, they have different, data protection rights or privacy rights, or perhaps none at all. And it was essentially, we could see how patchwork it was. Different organisations within our members were calling for different things. Some were calling for bans, some were calling for moratoriums, some were calling for legislation. And so what we decided to do was to come up with create a set of principles for police use of FRT in the hope that it could mitigate some of these harms. I won't stay too long on it, but basically our methodology was we just created a steering group within the network. We met obviously throughout. We agreed what information we needed. We surveyed our members to find out what actually information there is available in their jurisdictions. We agreed on the harms and risks, and we looked at the cases that were coming through. We looked at, obviously media stories as well. Not everything, ends up in court. And then we agreed upon a set of questions that we feel should always be asked when it comes to police use of FRT. And essentially the principles are our attempt at answering those questions. We did have some great expert feedback with a number of experts, academics and otherwise, and we did that virtually and in person. And essentially these are the principles. I don't want to take up all the time, but essentially there are 18 principles, and the first principle is about a legal basis. And essentially what we're saying here is that any interference with a right, and FRT interferes with many rights, as I mentioned earlier, must have a legal basis, and that legal basis must be of sufficient quality to protect against arbitrary interferences. We say that police cannot use FRT unless there is a legal basis. We also say that it should never be used in certain circumstances, and that includes it should not be used to identify protesters or collect information on people attending peaceful assemblies, which is very pertinent to what Adam's going to talk about. The second principle concerns mandatory fundamental rights impact assessment. So here we're saying that the police need to carry out a series of impact assessments with respect to all fundamental rights prior to any new use of FRT. And we're saying that these assessments must include an assessment of the strict necessity and proportionality of the FRT use. We have copies of the principles here if anyone would wish to go through them in more detail. They are quite detailed, so I won't go into detail of each of them. But obviously those assessments, we're saying they must explicitly outline, the specific parameters of use, who will use it, who it will be used against, where it will be used, why it will be used and how it will be used, the rights impacted, the nature and extent of the risks, how those risks will be mitigated, and a demonstrated justification for how and why the benefits of the deployment will outweigh the rights impacts, and the remedy available to someone who is either misidentified or whose biometric data was processed when it should not have been, which will speak to Tomas's point in a minute. Principle 3 is about the fundamental rights impact assessments that I just mentioned, having to be independent of the vendor assessment. It's not enough for a vendor to say that this is X and this is Y and everything is okay. And I'd like to mention here that Bridges case, the Court of Appeal case in the UK, which our colleagues Liberty took, because in that case, the Court of Appeal held that the public sector equality duty under the Equality Act there requires public authorities to give regard to whether a policy could have a discriminatory impact. And essentially in that case, it was held that the South Wales Police had not taken reasonable steps to make inquiries as to whether or not the FRT algorithm the police was using risked bias or racial or sex grounds. And the court actually heard from a witness who was employed by a company specialising in FRT, and he said that these kinds of details are commercially sensitive and cannot be released. And we hear this a lot, but it was held in the end, the court held that while that was understandable, it wasn't good enough, and it determined the police never sought to satisfy themselves, either directly or by way of independent verification, that the software didn't have an unacceptable bias. Principle 4 is no acquisition or deployment of any new FRT without a guarantee of future independence from the vendor. So this is about vendor lock-in, this risk that a customer would be at risk of not being able to transition to another vendor. Principle 5 is saying that all versions of all assessments must be made public before the deployment. Principle 6 is about the obligation of public consultation, and here we're saying that before any policing authority deploys FRT, it must hold meaningful public consultation. Principle 7, authorities must inform the public how probe images are used in an FRT operation. Principle 8 is about the technical specifications of any FRT system and how they must be made public before any deployment. Principle 9 is that live FRT should be prohibited. We do believe that live FRT is just too dangerous and should be banned. It is a red line. But as I said before, retrospective FRT can be just as dangerous. Principle 10 is about mandatory prior judicial authorisation. 11 is about record of use, and here we're saying that the police must document each and every FRT research performed and provide this documentation to the oversight body. I haven't mentioned it yet, but Principle 16 provides for an independent oversight body. Principle 12 is ensures that an FRT result alone would not be sufficient basis for questioning. And then obligation to disclose, there should be mandatory disclosure of the details of the FRT operation applied against individuals. Principle 14, any FRT misidentification of a person must be reported. And there should be mandatory annual reporting by authorities of those misidentifications in Principle 15. Principle 16 is the independent oversight body that I mentioned before. And that under Principle 17, that oversight body must publish annual reports. And Principle 18 is that the impacts assessment must be made available to the oversight body before the system is employed. And I need to move on very quickly to hand this over to Tomas. But basically, we hope that these principles, the aim of the principles is to, both help reduce FRT harms, but also empower civil society and the general population with it to kind of step forward and ask the right questions and push back and advocate for safeguards with a clear understanding of these technologies. We hope they can be used. The information can be used to voice their opposition, but also as an advocacy tool when debating and discussing FRT with law and policymakers. So for now, I will pass it over to Tomas, who can speak to a situation in Argentina and how they mesh with the principles.
Thank you very much, Olga. Hello, everyone. So I'm going to be talking a little bit about our experience in Argentina at CELS regarding the FRT. We've been working since 2019 in a litigation against the implementation of facial recognition technology in the city of Buenos Aires. I think this case provides a very interesting example regarding the importance of the ideas behind the principles that Olga was explaining just a moment ago. So very briefly, I'm going to talk about how the facial recognition system in the city of Buenos Aires works and how its what its legal framework look like. I'm going to talk about what the process in which we question the constitutionality of this system was like. I'm going to explain the principles that were set forth in the ruling by the local judges. And finally, I'm going to talk a little bit about how all this highlights the relevance of the principles that we were talking about. So first, regarding the system, the Fugitive Facial Recognition System in the city of Buenos Aires, or Sistema de Reconocimiento Facial de Prófugos in Spanish, was implemented in the city of Buenos Aires by a ministerial resolution on April 2019. According to the resolution, the system was to be employed exclusively to look for fugitives, that is to say people with pending arrest warrants, and exceptionally for other tasks specifically mandated by judges in individual cases. The system worked with the National Fugitive Database, the CONARC in Spanish, which provided the identities of the people that had to be searched for, that is to say, the fugitives, and with the National Identity Database, the Registro Nacional de las Personas, or RENAPER in Spanish, which was supposed to provide the biometric data regarding the people that had to be searched for, the pictures of these people, right, the fugitives. The system was operated by the local police, and in 2020, the local legislative branch sanctioned a statute that provided a legal basis for the system. So, regarding the case, it was a constitutional protection procedure, or amparo in Spanish. It was started by the Argentinian Observatory of Informatic Rights, another Argentine NGO, and CELS also took part in the case. The case started with focus on that which research on facial recognition technology around the world has repeatedly shown, that is to say, the risk of mistakes and wrongful identifications, racial and gender biases, and impacts on the right to privacy, and so on. However, as the judge started gathering information about the system, it became quite clear that there was another big problem, which was its practical implementation. So, as I said, the facial recognition system was intended to work crossing data between a national database of fugitives and wanted people, which consists of maybe 30 to 30,000 names, and the biometric data gathered by the National Identity Database. So the National Identity Database was supposed to provide the biometric data on those 30 to 30,000 people. However, when the judge asked the National Identity Database how many individual consultations the government of the city of Buenos Aires had made, it turned out that the government had made consultations about more than 7 million people, more than 9 million consultations in total regarding more than 7 million people. So clearly the Buenos Aires police and perhaps other offices were accessing this biometric data for other purposes, entirely different from searching for fugitives, and to this day we do not know exactly how and why this data was accessed. During the process, during the trial, a group of experts performed an audit of the system. They found that thousands of people had been searched by the facial recognition system without any legal basis, that is to say, people who were not fugitives. They also found that information regarding the use of the system had been manually deleted in such a way that it was impossible to recover it. And they found also that it was impossible to trace which specific public officers had operated the system. So, with all this, the local judge ruled that the facial recognition system employed by the city of Buenos Aires was unconstitutional. She found that the system had been implemented without complying with the legal provisions for the protections of the constitutional rights of the citizens. She also, in the ruling, she details that the legislative commission that was supposed to oversee how the system worked had never been created, that the other local organism, the Defensoría del Pueblo in Spanish, which was supposed to audit the system as well, was not provided with the information it needed to perform this task, that there were no previous studies to ascertain the impact of the system on the human rights, and that there were no instances for public participation prior to the introduction of the system. The ruling also explained that, as the court-appointed experts explained, it was proven that this system was illegally employed to search for people who did not have pending arrest warrants, and as I said before, local statutes provide that this was the only possibility, the only way the system could be employed. The ruling also held that local authorities had illegally accessed the biometric data of millions of people under the guise of employing this system. And finally, very briefly, the local Chamber of Appeals affirmed this decision and also added that the implementation of the system had to be preceded by a test performed by experts to ascertain if the software has a differential impact on people based on their race or gender. And finally, very briefly, I'm going to talk about the latest developments in the case. This order to perform the test to ascertain whether the system has a differential impact on people based on race or gender is still being carried out to this day. The government wanted to do a sort of black box test by selecting a number of people and testing the system on them. Our position here is that it is not enough to do a test of this kind, and that it's necessary for the government to disclose the technical details of the software and the datasets with which the software was trained. The government's position is that this information is a trade secret belonging to the company that provides the software, so this is a debate that is still ongoing. And finally, going back to the principles, the case was prior to the principles. It started in 2019, as I said, but I think it's a very good example of the relevance of the ideas behind the principles and the possible consequences of ignoring them. I mean, the serious irregularities that the judge found on the implementation of the facial recognition system are, we could say, the exact opposite of what the principles stand for. So, very briefly, to give the floor to Adam, thousands of people were looked for employing the system without any legal basis, directly against the ideas set forth in principle number 1. The system was implemented without any prior assessment of its impact on fundamental rights. This brings our attention to principle number 2. there were supposed to be 2 oversight bodies according to the legislation, to the framework of the facial recognition system. This looked great in theory, however, as I said, in practice, one of them wasn't even created, and the other one was not provided with information it required to perform its function. This regards obviously to Principle 16. No public consultation took place before introducing and employing the facial recognition system. This, of course, goes against Principle number 6. The use of the system wasn't properly documented, information was manually deleted, it could not be recovered, and it was not possible to tell which public officers had performed each operation. This, of course, regards to Principle 11. And the latest developments that I was talking about regarding how this test ordered by the Chamber of Appeals will be carried out, I believe highlight the importance of being able to access technical information regarding the system, such as the source code, the data that's employed to train the algorithm, and so on. And this regards to Principles 8 and 13. Thank you very much.
Thank you.
I might just introduce, maybe just to say, thanks a million, Thomas. I think it's safe to say that what you just described is exactly that. Like the principles, had they been, seen to or complied with or known about beforehand, it could have been a different scenario, and how things can go very wrong. And speaking about how things can go wrong, we're now going to turn to Hungary, and Adam's going to talk about the situation, about the recent legislative change there, that effectively has banned Pride this weekend, and also allows for the police to use FRT to identify people who have defied that ban. So, over to you, Adam.
Thank you very much for having me. I would like to present to you a case which may be good to demonstrate the practical problems with facial recognition, the ones that are formulated often quite abstractly, but which have absolute real-life consequences. The case of the Hungarian government essentially banning the Pride parade. So the background of the case is that the Pride is not a new event. It has been held since 1995, but in February of this year, the Prime Minister said that it would be banned because that was, in the government's views, necessary for child protection. So new laws were enacted. They essentially banned any assembly, quote-unquote, displaying or promoting homosexuality. And another law made it possible for facial recognition technology to be deployed for all petty offenses. Now, I will tell you more about what petty offenses are in this context. So the legal background of the case is that Hungary has had a Facial Recognition Technology Act since 2016. It established a facial recognition database, which consists of pictures of IDs, passports, and other documents with facial images on them. There are specific authorities that can request facial analysis in certain specified procedures from the Hungarian Institute of Forensic Sciences, which is responsible for operating the facial recognition system. And a novelty of Hungarian FRT use was that in 2024, FRT was made available for use in infraction procedures or so-called infraction procedures by the police. And in 2025, this included all infraction procedures. The reason why this is important is that participating in a banned event, an event that had been previously banned by the police, is an infraction. So if demonstrators gather at the Pride event after it had been banned by the police, it would mean that they would collectively commit infractions, probably in the tens of thousands. So let's find out how the FRT system actually works in this scenario. The police are known to record demonstrations, and they can use CCTV and other available sources too to gather photographs or images of a certain demonstrations. If they find that there is an infraction happening, what they can do is that they initiate an infraction procedure, and in the course of that infraction procedure, send the facial images to the central FRT system, which then runs an algorithm and identifies the closest 5 matches, which are then returned to the police, and it's the police officer operating this system who has to decide whether there is a match or not. I have to point out that this system has never been used en masse, so it has never been used against tens of thousands of people, and it is not known how this system itself will technically or the capacities of the judiciary and the police will operatively handle this kind of situation. So what we can tell about the case is that in the FRT principles, well, it's the first principle that it must be ensured that FRT is not used to identify protesters or collect information on people attending peaceful assemblies. This is the first principle, and it is immediately violated by this this kind of FRT use against peaceful demonstrators. Another principle is that there are certain uses which are banned according to the principles, such as that no FRT system will be used on live or recorded moving images or video data. We can see why it is a problem that the police record entire demonstrations. They don't even necessarily have to follow a demonstration with live facial recognition. It is enough for the chilling effect to take place to record everyone who is taking part in the demonstration, to then later systematically find everyone in the police's recordings and then send fines to them, which is actually probably how this will play out in Hungary, or at least how the government plans it to play out. And it is an interesting case study of the lack of transparency around facial recognition. One of my conclusions will be that FRT in this present case is used actively to discourage people from attending demonstrations, but the lack of transparency, the lack of knowledge that people have of what is going to actually happen to them is also as discouraging as the outright threats of using FRT. So in the case of the Hungarian system, we can tell that there was no public consultation whatsoever before the introduction of the entire system in 2016. So the introduction of facial recognition as such was done in Hungary without any public consultation or without it being communicated to the public. Which means that there is no public awareness, or that there hasn't been up until now, when the situation has gotten worse, public awareness of even the existence of the FRT system. There was no consultation and consultation with the public, no data protection impact assessment, and no consultation with the Data Protection Authority before the present broadening of the scope of FRT, which would of course include this massive breakdown on the freedom to assembly. This also violates one of the articles of the protocols. So it can also be said that there are no records of use, no statistics available that would tell you how the system works, how effective it is, when it is deployed against which kinds of infractions whatsoever, and persons prosecuted can almost never find out whether the FRT has been used against them or not. There are no impact assessments before the individual uses of the system, which means that the police can simply just initiate these searches without assessing the possible effects that it would have on someone. This is also against the principles. There is no vendor lock-in assessment either, which is also important because, the Hungarian Institute of Forensic Sciences, which operates the system, explicitly said that they were only clients using this facial recognition algorithm, which raises the question of whether the data are being transferred to third countries or not. And of course, since there are no risk assessments, they haven't been publicized either, which also goes against the protocols. So a lack of sufficient oversight is also what I would like to mention. There is no prior judicial authorization. This is important because, as I have told you, it is necessary to start an infraction procedure before FRT can even be deployed. It is not known because the law is not clear about against how many people at the same time can one infraction procedure be initiated. So this has never even really been used against more than 3 or 4 people, which makes sense. But it has never been used on a scale of tens of thousands of people. A prior judicial authorization could act as a check on this kind of massive surveillance if a judge could see whether it was necessary to surveil tens of thousands of people at the same time, but it's not possible. There is no independent oversight body either, and of course there are no annual reports, no notification of the impact assessments to the oversight body, since the oversight body does not exist. So these all go against the provisions, I think, in a very concrete manner, so that you can see that these provisions are not just abstract rules, but they are, when they are not met with, that means actual harms in real life. My conclusion would be that what we can see is a weaponization of facial recognition technology, that instead of mitigating the risks, there is a deliberate abuse of FRT's most invasive properties. Essentially, the government actively communicated that facial recognition would be used against people that they cannot hide because they will be found with facial recognition and they will be fined. It is inevitable. This, of course, has a massive chilling effect on the freedom of assembly. And we could also say that even the lack of transparency is kind of weaponized. Because if there is a lack of information on the system, it is impossible for people to calculate the risks. This will have a chilling effect on them because they won't know whether it is true that they will actually all be found and fined. So I would like to conclude here. Some possible next steps are legal avenues that can be taken, like the law enforcement directive in the EU or the AI Act, and in-close principles can, I think, also be used in advocacy at international fora. Thank you.
Thanks, Adam. I wouldn't mind if you don't mind. I might just ask a follow-up question. Given the situation that's happening in Hungary, and given it's so imminent this weekend, and it has got such international attention, how have the people in Hungary? How are they feeling? Like, what's the public opinion about the use of FRT? Has it changed? Like, did people kind of care before, or how is it now?
Well, people, I think, never really cared about FRT because they didn't actually know that it existed. Precisely because the lack of communication on the government side. So the situation had to become this bad and severe for the people to start to even care about the problem. But now the system already exists with the rules that we have now and which can be abused by the police and the government. So many are concerned now, but proactive communication should have been necessary on the government's part.
I just wonder if we have any questions.
Hi, can you hear me?
Yes.
Okay. I'm from Brazil. My name is Pietra, and the situation in Brazil with facial recognition is growing really fast. I think it's very similar to what is happening in Argentina, but I was really shocked with the Hungarian case. And I'm a part of a project that is trying to do some community activations about facial recognition in use in police. So I wanted to hear from you if you ever done something with community activation. And also I wanted to ask if you believe that there is a way to use facial recognition or if you think that it should be banned. Because in Brazil, we are discussing a lot about the banning all systems that use facial recognition. So I wanted to listen from you guys. What do you think about it? Thank you.
Thank you. I can have a go at answering some of those questions. I think the idea of getting into communities and doing that education awareness piece, which is I think what you're talking about, and maybe activating them or stirring them into taking action is really, really important. Mainly because of the same issue that Adam just mentioned. You know, people don't really understand it, don't really know about it. And then when people are talking about it, people in position of authority speak of it as a silver bullet solution with this, you know, there's no problems, it's like control and F, there's no issues. And just and absolutely downplay the risks. So I think you have to get creative. I think you have to get creative with maybe local artists. ICCL created a mural with a local artist in Dublin to highlight the dangers of FRT. But it's also kind of getting looping in with other civil society organisations who might not work in this space, and getting down to that kind of grassroots level. I think you just have to kind of get imaginative. You're trying to get the word out there, and I think use all the tools available to you that you would use in general for communications. I think when it comes to a ban, INCLO rather, like I said, we have 17 members in 17 different jurisdictions. There are already 17 different sets of kind of safeguards and protections there in place. Some people are calling for a ban, some people are calling for a moratorium, and other groups are calling for legislation. It really is specific to the jurisdiction and what's happening there. But what we do know is that the risks and the harms are present, they're pressing, that mass surveillance risk and how this can be quickly deployed against us is clear and obvious. From many of our perspectives in INCLO, we would call for a ban. We don't wish the police to use it. But we know that fight has been lost in certain jurisdictions, so this is an attempt to try and make it better, at least. I hope that helps. Hi.
Hello, my name is June Beck from Youth for Privacy. I was wondering, since we're talking about facial recognition technologies, there's also been a lot of movement to penalize wearing masks in public as an attempt to protect yourself against facial recognition technology. So I was wondering if INCLO or any organization have thoughts or processes or any kind of discussions on how the ban of facial masks, for example, is also in conversation with FRT.
I don't wish to take over the conversation. You might have something to say.
Not really pertaining this, maybe a little, but if you have.
We're out of time. I would say that that's happening. More and more laws are being passed to ban face masks at protests. It's on the cards in Ireland as well. It's happening in England. It's changing to be more restrictive in England. It is happening, and it's impossible to see how that's not a response to the use by police of FRT, and then the response of the public to cover their faces. So it's not something that we've worked on specifically yet, but it's absolutely something that we are working on individually, if you like. Yeah.
All right, thank you.
Thanks a million. Sorry, we've gone over time. We're very happy that you joined us. We hope that you enjoyed it and that you found it insightful. Thanks very much. And we have copies of the principles and hard copies if you wish. Thank you.
Thank you very much. Goodbye.
Thank you. Goodbye.
Workshop 2. 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 Workshop 2.